Now I would request Mr. Munzur Hassan Obi, Executive Director, Center for Peace and Justice, BRAC University and Chairperson, Action in Bangladesh, for his opening remarks.
Thank you very much, and good morning, everyone. A very warm welcome. Guest of honor and special guests, Your Excellencies, all other dignitaries, members of print and electronic media, distinguished guests, ladies and gentlemen. I also welcome those who are following us on Facebook live streaming. On behalf of my fellow conveners, I was tempted to say fellow conspirators, but fellow conveners, Professor Imtiaz Ahmed and Ms. Farah Kabir, it is my immense pleasure to welcome you all this morning and to thank you for making the time to attend this important seminar, which has been jointly organized by ActionAid Bangladesh, Center for Genocide Studies, and the Center for Peace and Justice. Today's seminar, Accountability, International Criminal Court, and the Rohingya Crisis, is about more than 1 million Rohingya refugees and their deportation from Myanmar to Bangladesh as a consequence of what a recent UK House of Commons report described as, I quote, deliberate, state-sanctioned, long-term ethnic cleansing of the Rohingya people. I repeat, deliberate, state-sanctioned, long-term ethnic cleansing of the Rohingya people. This is a report that came out from the House of Commons, I think, last month. The matter has now come before the International Criminal Courts at The Hague. On 7th May, a letter was sent to the ICC prosecutor to the government of Bangladesh seeking letters opinion on the issue of jurisdiction. The deadline is 11th June, another week from today. The ICC prosecutor has already very eloquently argued that the court has territorial jurisdiction due to the fact that the deportation of Rohingyas from Myanmar involved movement into Bangladesh, which is a party to the Rome Statute. We have three very distinguished guests who will be sharing their thoughts on this and other issues. We look forward to hearing from them. Let me end by citing from a recent article that I wrote, and I quote here. The government of Bangladesh has to be far-sighted in presenting its case to assist the ICC to advance international law and accountability. Given the fact that Bangladesh has already won the hearts and minds of millions of ordinary people by its unprecedented generosity and hospitality, Prime Minister Sheikh Hasina's government has to occupy the high moral ground, which they already do, and the hope is that they will continue to do so. Whatever outcome of the ICC process, history will record Bangladesh's desire for global peace and justice under the leadership of Prime Minister Hasina, if the letter and spirit of accountability is embodied in the response to be submitted by 11th June 2018. So I will not lengthen my opening welcome speech. I would like you all to hear what our guests have to say. So I again thank you for your presence, and hope you will have a fruitful morning. And we also wait to hear from you when we have a question and answer session. Thank you very much.
Thank you, sir. Now I'd request Justice Syed Rifat Ahmed, sir, for his remarks. Sir.
The conveners of this seminar, the guest of honor, special guest, ladies and gentlemen, good morning. Taking a cue from the op-ed that was published several days ago, penned by Barrister Manzoor Hassan, I am tempted to begin by referring to the Constitution of the People's Republic of Bangladesh and take you to the very opening provisions in the form of the preamble to the Constitution that incorporates in emphatic terms an intent to make Bangladesh's full contribution towards international peace and cooperation in keeping with the progressive aspirations of mankind. That preambular provision finds specific content in Part 2 of the Constitution that incorporates what are known as the fundamental principles of state policy. They basically remain unenforceable through a court of law, but they nevertheless remain essential to the governance of Bangladesh as declared in Article 8.2. It is Article 25 of Part 2 that deserves mention here. And it states that the state of Bangladesh shall base its international relations on the principles of peaceful, inter alia, peaceful settlement of international disputes and respect for international law, and by subscription to the principles enunciated in the UN Charter. And it is on the basis of these principles that it is declared that Bangladesh shall extend support to oppressed peoples throughout the world, waging a just struggle against imperialism, colonialism, and racialism. The subscription to the UN Charter is significant for our purpose this morning, given that Article 2.3 of the UN Charter makes it imperative for all member states like Bangladesh to settle their international disputes by peaceful means in such a manner that international peace and security and justice are not endangered. The notion of settlement of international dispute by peaceful means gets further to be enunciated in Article 33.1 of the UN Charter. And it says that the parties to any dispute, the continuance of which is likely to endanger the maintenance of international peace and security, shall first of all seek a solution by negotiation, inquiry, mediation, conciliation, arbitration, judicial settlement, resort to regional agencies or arrangements or other peaceful means of their own choice. It is against that constitutional dispensation that this country today, and as of the 25th of August 2017, has seen and experienced more than 670,000 Rohingyas being driven out from Myanmar into its territory. About 50% of the Rohingya refugees are children, and an estimated several thousand of whom are unaccompanied and separated from their families. According to eyewitness accounts of the atrocities, the Myanmar army has been involved in the rape, murder, and significantly deportation of Rohingyas. The cross-border humanitarian crisis affecting the Rohingya population has been described as a textbook example of ethnic cleansing by the UN High Commissioner for Human Rights. Whether the perpetrators of these atrocities can be held accountable before the International Criminal Court, the ICC, remains a contentious issue, not least because the country in which the offenses have originated, Myanmar, is not a party to the Rome Statute, which established the ICC, and has not accepted ICC's jurisdiction under the statute by reference to Article 12.1. In my address today, I would like to set out an overview of the legal framework for the ICC's exercise of jurisdiction given such a scenario. On 17 July 1998, a conference of 160 states in Rome established the first treaty-based permanent international criminal court. The Rome Statute sets out the crimes falling within the jurisdiction of the ICC, the rules of procedure, and the mechanisms for states to cooperate with the ICC. Article 5 of the Rome Statute provides that the ICC has jurisdiction with regard to genocide, crimes against humanity, war crimes, and the crime of aggression. Crimes against humanity, interestingly, have been further defined in Article 7 to the statute to include, among others, the offenses of murder, extermination, and deportation. There are theoretically 4 ways in which the ICC may exercise jurisdiction over crimes committed by the Myanmar authorities. 1, through the reference by a state party of investigation by the ICC prosecutor. 3, by reference of the dispute by the UN Security Council to the ICC. And 4, by the acceptance of the ICC's jurisdiction by the state in question, which would be Myanmar, which seems to be pretty far-fetched under the circumstances. On the issue of reference by a state party, we come to Bangladesh as a state party, which may refer the matter to the Office of the Prosecutor for investigation by reading of Article 13A and Article 14 of the Rome Statute. Bangladesh ratified the Rome Statute in 2010 and has thus submitted itself to the jurisdiction of the ICC with regard to crimes referred to in Article 5 of the statute. Now, under Article 12.2 of the statute, the ICC may exercise its jurisdiction where A, the alleged perpetrator is a national of a state party, or B, where the crime was committed in the territory of the state party. It's the latter aspect, the territorial jurisdiction aspect of it, which the ICC is counting on at this point in time. In the present case, although the alleged perpetrators are not nationals of the state party, it may be plausibly argued that the offense in question have been partly committed in the territory of a state party, that is Bangladesh, and that therefore ICC has jurisdiction in respect of the offense in question. In the application under Regulation 46.3 before the pre-trial division of the ICC for a ruling on jurisdiction, the Office of the Prosecutor has argued that the offense of deportation, which requires victims to cross an international border, has been partly committed in the territory of Bangladesh. Article 12.2a of the statute provides that the ICC may exercise its jurisdiction if the conduct in question occurred on the territory of a state party. It would be prudent to draw your attention in this regard that there is an agreement or a consensus in international law that states have jurisdiction over crimes committed only partially on their territory. Here, one may invoke the notion of subjective territoriality, that is, when crimes are committed on a state's territory but concluded in another state, or the notion of objective territoriality, when crimes are committed on a state's territory being initiated elsewhere. It's the latter principle that is being invoked by the Office of the Prosecutor in this case. And the Office of the Prosecutor is of the view that since the conduct requirement is fulfilled if at least one element of the Article 5 crime is committed in the territory of a state party, the ICC may exercise jurisdiction under Article 12(2)(a), either if the originating party is a state party or if the receiving state is a state party. It is the latter which is true in this case, the receiving state being Bangladesh and a state party. In the present case, one of the constituent elements of the offense of deportation, that is, the crossing of an international border under compulsion, has taken place in the territory of Bangladesh. It may thus be argued, by relying on the objective territorial principle, that the conduct in question, that is deportation, occurred in Bangladesh, and that the ICC may exercise jurisdiction over any crime or deportation from Myanmar into Bangladesh. It should be borne in mind at this juncture that Article 12(2)(a) of the statute delegates the state parties sovereign powers to assert jurisdiction over Article 5 crimes to the International Criminal Court. As such, akin to a state's sovereign powers to assert jurisdiction over acts occurring in the territories of multiple states, the ICC too may exercise jurisdiction over offenses which originated in one state but were completed in another state. Furthermore, the law and practice of various states, including Bangladesh, show a willingness to exercise jurisdiction over crimes committed in only a part of their territory. For instance, Section 5 of the Prevention and Suppression of Human Trafficking Act 2012, a municipal law in Bangladesh, expressly recognizes the extraterritorial application of the said act. According to Section 5.2, the offense of human trafficking is deemed to have been committed in Bangladesh if it commences outside the territory of Bangladesh and is completed inside its territory. Thus, crimes which are committed only partly within Bangladesh are tried and punished under municipal law as if they have been committed within the territory of Bangladesh. But perhaps the most compelling argument for the exercise of jurisdiction by the ICC is that the Rohingya people were specifically and intentionally deported by the Myanmar authorities into the territory of Bangladesh. Not only is Bangladesh the receiving state of such refugees, but also its territory has been specifically targeted by the Myanmar authorities for commission of the cross-border crime of deportation. As such, the receiving state, and by extension, the ICC, has sufficient interest in the matter to assert its criminal jurisdiction over the crimes in question. Once it is established that the ICC has jurisdiction over the crime of deportation, Bangladesh may, as a state party to the Rome Statute, request the Office of the Prosecutor under Article 14 of the statute to carry out an investigation into such crimes. There have been numerous examples by referral of state parties in the past. In December 2003, Uganda referred to the prosecutor the situation with regard to the Lord's Resistance Army. In 2004, Congo and the Central African Republic referred to the prosecutor the offenses committed within their territories. In all three cases, investigations were commenced and arrest warrants duly issued against the alleged perpetrators. Secondly, even if the Bangladesh government does not make a request under Article 14, it is open for the prosecutor to act on its own initiative, i.e., proprio motu, under Article 15 of the statute to open an investigation into the matter. If the prosecutor is satisfied that there is reliable information regarding crimes involving nationals of a state party or crimes committed in the territory of a state party, the office of the prosecutor may initiate an investigation into the matter after obtaining permission from the pre-trial chambers. Thus, for instance, the ICC pre-trial chamber granted the prosecution authorization to open an investigation pro prio motu in the situation in Kenya in 2010, culminating in the framing of charges against 4 individuals, including President Uhuru Kenyatta. Thirdly, the ICC may also exercise jurisdiction under Article 13b of the statute if the UN Security Council, acting under Chapter 7 of the Charter of the United Nations, refers the commission of crimes to the office of the prosecutor. Such a referral is binding in nature, and there is no necessity for the relevant state to be a party to the statute. This happened with regard to the situation in Darfur, Sudan, which was referred to the prosecutor in 2005 by a UN Security Council resolution. After a preliminary examination, investigation was commenced and arrest warrants issued against high-ranking civil and military officials. Similarly, the situation in Libya was referred to the prosecutor by the Security Council in 2011, has resulted in warrants of arrest, notably for Muammar Gaddafi and others, but that had mixed outcome and results. It is worth noting that notwithstanding provisions of Article 33 and 34 of the UN Charter that speaks of, that makes it incumbent upon the Security Council, as it deems, when it deems necessary, to call upon the parties to settle their disputes by peaceful resolution, as set out elsewhere and as I've referred to earlier in the UN Charter. Notwithstanding these binding provisions of the UN Charter, and as we can all see at the present point in time, the United Nations Security Council proceedings, wrought with political and strategic and diplomatic positioning, result in political exigencies invariably taking precedence over moral or legal, strictly legal considerations. Exercise of the power of veto on geopolitical considerations is still likely in the near future to get in the way of a favorable UN Security Council resolution over the Rohingya crisis and manifesting in a referral to the ICC under Article 13b of the Rome Statute. Of course, as I alluded to earlier, it is open for the ICC to exercise its jurisdiction if Myanmar lodges a declaration with the registrar of the ICC that it accepts the jurisdiction of the ICC under Article 12.3 of the statute. But I think we are all in agreement that it would be foolhardy under the circumstances to expect Myanmar to accept the jurisdiction of the ICC. But this remains theoretically an avenue for exercise of the court's jurisdiction and should be on the table for our discussion. To conclude, I would like to submit that as far as the Rohingya crisis is concerned, the most obvious route for exercise of jurisdiction by the ICC would be if A, Bangladesh refers the matter to the prosecutor for investigation under Article 14, or B, the prosecutor, pro prio motu, initiates an investigation into the matter. The ICC Chief Prosecutor's request for a ruling on jurisdiction is currently pending with the pre-trial chamber, as we've heard earlier. A favorable ruling by the pre-trial chamber would, one hopes, pave the way for an investigation by the Office of the Prosecutor into the alleged crimes committed by the Myanmar authorities, ideally under Article 14 of the Rome Statute, putting the ball in Bangladesh's court. Thank you very much.
Thank you, sir. Ladies and gentlemen, now I'd like to request Ms. Kate Vignesoran, Consultant, United Nations Office on Drugs and Crimes and former ICC prosecutor on the Yugoslavia Tribunal, for her remarks. Thank you.
Thank you. I think I'll need to scroll through the screens. Is it possible to fill out that podium? It might be. Would be ideal, and then I don't have to signal every time I need to. Thank you very much. There we go. Good morning, everybody. I'd just like to thank the conveners for having me here today, for inviting me. I'm very grateful for this opportunity to speak to you about the application and to be on a panel with the other honourable guests. Thank you so much, Judge Ahmed. I think you've covered quite a lot of ground and saved me the trouble of covering it as well. There's going to be a little bit of overlap in the ground that we've covered, but I'm going to come at it from some different angles and highlight some of the more technical difficulties that this application raises. Being the lawyer that I am, I have prepared a PowerPoint presentation to guide you through some of the steps and the sort of technical components of the argument that the prosecution at the ICC has raised. It certainly helps me to visualise, and I'm hoping it will help you to actually see some of the language on the screen. Before I get into the details of the application, I wanted to just put it in context, and I think Judge Ahmed has done a very good job of already doing that with describing the crimes that have been committed against the Rohingya community in Myanmar, so I don't want to go through that again. One thing I wanted to just add to that is we shouldn't forget that the Rohingya are not the only victims of crimes in Myanmar, that there are other religious and ethnic groups that suffered through the attacks. There's a lot of debate going on at the moment about who's responsible for those crimes, which I think we don't need to get into here, but that this application, although largely focused on the Rohingya, also has potential implications for accountability for the crimes against these other groups. So the other contextual element I wanted to talk about was the purpose and intent of the International Criminal Court itself. Now, the court was established specifically to try these types of crimes. We had seen for the decades before the proliferation of other courts and tribunals that are very costly and were selective. And so the court was established to try and get around some of those issues and fill an impunity gap. And we can see that in the preamble to the Rome Statute, which talks about the most serious crimes of concern, about them not going unpunished, about ending impunity, and about the duty of every state to exercise its criminal jurisdiction over these crimes, and eventually resolving its resolve to guarantee lasting respect for the enforcement of international justice. So the concept of the court itself is based on this principle of complementarity, which is that states should exercise jurisdiction over these crimes. Every state that has a jurisdictional basis should exercise jurisdiction over these crimes, but where it's not willing or able to do so, the International Criminal Court will. So the entire model of the court is based on a diminution of state sovereignty, and that's what all of these courts do. So let's go to the application itself. There are three key issues that the application raises. I'm going to talk about two of them. The third one is around the process for making the application, the procedure that it should apply. There's virtually no guidance in the rules of procedure and evidence or the statute about this process, and it's something that Bangladesh may want to weigh in on in its submissions, or other amicus might want to weigh in on their submissions. There are some sort of due process issues there, but I'm not going to talk about those today. What I'm going to talk about is what is the nature of the crime of deportation under the Rome Statute, and what is the nature of territorial jurisdiction. So first, deportation, as Judge Ahmed's already pointed out, is a crime against humanity under Article 7(1)(d) of the Rome Statute, as is forcible transfer. It's also a crime under the International Crimes Tribunals Act in Bangladesh. So Bangladesh has jurisdiction over deportation and a range of other crimes against humanity which have been committed. The elements of deportation are set out in the Rome Statutes, in the elements of crimes. This is where we understand what deportation actually means. So as there has been lots of discussion, the element of forcing a victim across a border is carried out in Bangladesh, arguably. But I think it's important to see how the elements play out. So the elements that are committed in the deporting state are that the perpetrator deported or forcibly transferred the victims. They were lawfully present in the area. It occurred without grounds under international law. It was part of a widespread and systematic attack on a predominantly civilian population, and the perpetrator or other actor had the requisite intent and knowledge. There's your border. Recipient state to another state or location. And this visualisation, I think, is helpful when we get to the question of territorial jurisdiction and what that actually means and when that kicks in. There's been a lot of debate around what another state or location means. And that's because it has implications for the scope of jurisdiction. Probably not in this case, but for other cases. So under customary international law, so that's the law being applied by other courts and tribunals, it means across an international border. Now, a border can be at sea, a border can be at land. So effectively that means anyone deported into the high seas has been deported. Anyone deported to another state has been deported. But the language in the elements is to another state or location. Now, some people connect deportation with state and forcible transfer with location. What that would effectively mean is that deportation only occurs when you transfer someone to another state's territory, but not to the high seas. This would obviously not accord with international criminal law, would leave a significant impunity gap. This is not something that the prosecution has really dealt with, but it is an issue that is being discussed, because the implication is if a person is deported to the high seas and then they make their way to another state, does that state have jurisdiction? Does that mean if that state is a state party, all of a sudden, because that person elected to go to that particular state, they can prosecute the crime, or the court can prosecute the crime? The prosecution deals with this, or doesn't deal with it, by talking only about direct deportation. So they say in their application they want to verify the court has jurisdiction where a person is deported from the territory of a state which is not a party to the statute directly into the territory of a state which is a party to the statute. And they repeat this language later on in their application, where they talk about deportation directly into the territory of a second state after crossing an international border. This is an issue that's come up in amicus submissions, one particularly by the Canadian Partnership for International Justice, who indicated that they will deal with this issue and whether or not deportation into another location would be sufficient. So I'm going to talk about territorial jurisdiction now and what territorial jurisdiction is. As the Honourable Justice has already set out, the application is based on Article 12(2)(a) of the Rome Statute, which already indicates that... sorry for the formatting, already indicates that one or more states might have jurisdiction over the same crime where it's occurred on the territory in which the conduct in question occurred. So what does territorial jurisdiction mean? Well, the traditional concept we all know is where a crime is committed on the state. That state has the right to exercise its criminal jurisdiction. But that has evolved over time. So we've got subjective and objective territorial jurisdiction, and as the Honourable Justice pointed out, the prosecution's application is based on the notion of objective territorial jurisdiction. Now, the prosecution has done a very good job of setting out the domestic and international basis for the exercise of objective territorial jurisdiction. It refers to domestic law, it refers to international law, and it refers to state practice, so through judicial decision making. Now, the exercise of that jurisdiction is not uniform. So some states say where the effects or consequences or results are felt on the territory. Some say when one of the constituent elements occurs on the territory. Some say part of the offence. Some say a substantial measure. And it goes on and on. There's various different ways of describing it. And it's a spectrum. So some will exercise jurisdiction where none of the elements of the crime have been committed on their territory, but the effects are felt there. This is often used in anti-competition law, so where companies collude in violation of competition laws elsewhere and the effects are felt on the state, they will exercise jurisdiction, right up to where most of the elements occur. This makes sense, you know, we're living in a modern global world where people are moving across borders all the time, money is moving across borders, crimes are being committed across borders, and you can see this in terrorism cases, trafficking cases, corruption cases, and a range of other offences. So it really makes sense that the law is developed in this way. The question for the court, which I think is going to be a very difficult one for them to decide upon, is just where do they sit on this spectrum? The prosecution has put forward its position and it says no to effects-based jurisdiction. It says at least an element of the crime must be committed on the territory. So it sits somewhere around here. It says the crime must be committed in whole or in part on the territory. They've relied on this before. In another case, although there wasn't a court order on it, it was in relation to South and North Korea, where North Korea fired shelled onto a South Korean island, and they found that they had the right to investigate that, even though North Korea isn't a party to the statute. Now, I'm just going to go back. Sorry, why do they do this? Well, one, effects-based jurisdiction would be much harder to prove. It'd be much harder to show that there's an international law basis, or that under the general principles of law applied by domestic states, that this is actually a uniform practice. And they don't need to. If we go back to the elements, they don't need to. An element of the crime here has been committed in Bangladesh. And they have to, because if we go back to Article 12, it says the state on the territory in which the conduct in question occurred. So some of the conduct must occur in Bangladesh. If it's just an effect, I think it would be hard to fit that into the concept of conduct. So the question for the court is, how many of these elements? Is one enough? And there's also the question of which elements. Elements can be broken down into, you know, the acts of the perpetrators, the consequences of the crime, the intent and knowledge of the perpetrator. And this is obviously relevant here because the arrival of victims into Bangladesh is a consequential element. It doesn't. It's the result of the perpetrator's acts. The statute is ambiguous about what this notion of conduct means, because if we look at this provision alone, it says the territory of a state in which conduct in question occurred, or if the crime was committed on board a vessel or aircraft. It doesn't make sense for them to use different terminology, to use conduct in one sense and crime in another. they must mean the same thing. So you would imagine that they both mean crime and therefore all of the elements of the crime, but I'm not going to go through the detail. There's elsewhere in the statute and the elements where they interchange these terms. They also use conduct and consequence and differentiate between them. I think this is where the crux of some of the decision making here is going to get quite tough for the court. According to the OTP or the prosecution, the type is irrelevant. It doesn't matter. It can be a consequential element, it can be a conduct element, it can be a intent element. It's just as long as it's within the second territory. I want to just flag some additional arguments that have been raised by amicus curiae submissions. We haven't seen the full extent of those submissions yet because they're not yet due, but some of the amicus in their applications for standing have indicated what they intend to argue. One is that deportation is continuing, that it wasn't complete or it didn't end at the time the victim crossed the border, that until those victims of deportation are able to return to Myanmar, to their homes, they're still being deported. So they're still being deported right now. They've argued deportation and other acts, so sexual violence, some of the other acts around the systemic discrimination of the Rohingya constitute apartheid and constitute persecution as a crime against humanity, both of which are continuing for the same reasons as deportation is. That sexual and gender-based violence and possibly deportation might constitute acts of genocide because the serious bodily and mental harm is still being felt while the victims are in Bangladesh. So these are all crimes that the court may still have jurisdiction over. And conditions of life calculated to destroy because the perpetrators intended to push the Rohingya into a situation in which they couldn't, they don't have livelihoods, and which they expected that they would be in a situation which would destroy the group. These crimes are still continuing. And as I've already flagged, deportation to another location is sufficient and not limited to another state. So what are the implications for ICC jurisdiction? Well, if the court says they have jurisdiction, just checking if I have time. 1 minute, okay. If they say they have jurisdiction, so they'll have jurisdiction over crimes where one or more elements committed on another territory is carried out. So theoretically, this doesn't have to be limited to deportation. It can be, as I've mentioned, cover things like genocide, cross-border killings, and any other continuing crimes that occur across the border. They'll have jurisdiction over other deportations into contiguous territories, so people have already been flagging the possibility that this might give a basis to exercise jurisdiction over deportations from Syria, for example, into contiguous states, in jurisdiction over victims who are in Libya who have been deported from contiguous states. It will not necessarily grant jurisdiction over deportation into the high seas, unless they get into the issue of indirect deportations, which I don't think they will. I think they'll limit it to the prosecution's application. I think the important thing for the court will be to set out some limits to prevent overreach of this principle. And this is done in domestic law all the time. They use a reasonableness test or other tests to ensure that the court isn't just exercising its jurisdiction to intervene where it shouldn't be. And there'll be other factors like gravity. So the court is, or the prosecution's not going to exercise jurisdiction unless the gravity requirement has been met. So for Bangladesh, I'm going to leave it to the Honourable Mr Ruddock to talk about the politics involved. I'm a lawyer, not a politician, but I do have thoughts on what this could mean for Bangladesh and what the implications are if jurisdiction is granted. Well, firstly, Bangladesh itself is in a position to prosecute these crimes if it can has the domestic law basis to do so, and the fair trial standards are met, so due process standards can be met in a way that satisfies the requirements under the Rome Statute. So if they get jurisdiction and the Bangladesh decides to prosecute, the court will defer to them. I think this could also, and I think there's obviously going to be a lot of debate about this, has the potential to defer future attacks. I think one of the things that we've seen since the late 1970s, where the Rohingya have been increasingly persecuted, increasingly attacked, and now almost all of the population has left and is in Bangladesh, is impunity. No one has done anything about accountability for these crimes. There have been various steps here and there, but nothing that's really been significant that actually has a deterrent effect. I think we all know, or from my understanding, Myanmar is concerned about accountability. And I think that this actually has the potential to really have that effect. And I think this is important for improving the humanitarian situation. I think you cannot repatriate these people to a situation in which they're going to be persecuted again. I mean, that's very clear under international law. And in order to facilitate repatriation, you need to have a situation in which they can actually go back. With no accountability, no pressure for them to change the systemic discrimination, the continuing perpetration of abuses, that's not going to happen. I was going to talk about Bangladesh's role in the development of international criminal justice, but I think the Honourable Justice has already talked about the Bangladesh framework sufficiently, so I'll leave it there. Thank you.
Thank you. Thank you, Ms. Kate Vignesoren. And now, ladies and gentlemen, it's time for remarks by our guest of honor for today's seminar, Honourable Philip M. Ruddock, Member of Parliament, former Father of Australian Parliament, and Mayor of Hornsby.
Well, thank you very much, Madam Chair. Can I acknowledge particularly Director Mansour Hassan, Justin Ahmed, Kate, our consultant, Professor Ahmed, and friends. It's a great pleasure to be here, and I feel greatly honoured that you have asked me to participate, but I must say you have me here under false pretences if you think I am in some way expert. I come to this role unable to correct anything that our distinguished lawyers have said. I have listened very carefully to the observations they have made, and particularly the importance of jurisdiction of the International Criminal Court, the extent to which Bangladesh may be able to seek to engage it, and the extent to which it can be undertaken unilaterally by prosecutors. We've heard Kate talk about the Rome Statute. I noted particularly in the observations she made that you can deal with deportation as a crime against humanity. You can deal with it. But when you look at some of the elements involved, I think they are particularly difficult to prove. The one that I focused on was that if you were going to deal with deportation, for instance, you had to be able to prove that the person was in fact a resident lawfully in the state. And you had to be able to show that the state knew, that's how I read it, that they were lawful residents. They sound like tests. I came here very much as a student. I may be a lawyer, I may have been formerly an Attorney General, I may have been a Minister of the Crown for some years, 40 years in Parliament. What it does is it gives you a degree of capacity to argue, but it doesn't make you expert. I'm not an expert on the law. But what I do know from what has been said is that if we're going to play any role in relation to getting these matters up before an international court and to have the perpetrators dealt with, we have to have the evidence. I want to spend a moment providing a little bit of context, if I may. I am a retired parliamentarian. Being a local mayor may give me some title, but I am a retired parliamentarian. I was involved for Australia as its special envoy for human rights. I have had a passion about human rights over all of my time in public life. I've been almost a life member of Amnesty International, a very worthy organisation that opposes the death penalty, that is focused on torture and seeks the release of prisoners of conscience. And I must say, they are issues that I have been pursuing all of the time that I have been involved in public life, often with great difficulty. They're not easy issues to deal with. But I want to see change. I had the opportunity as Australia's envoy for human rights to be able to argue that we should play a role in bringing a better understanding of human rights issues to the international community. And we were seeking election to the UN Human Rights Council and were recently elected to it. And in part, my role helped achieve that outcome for Australia. I don't know how well we'll undertake the task, but one of the roles of the international community coming together in the Human Rights Council will be to get these matters up and argued. My interest in these matters may be one of the reasons I have been asked to participate. I had the opportunity of participating recently in a conference in Germany, Cologne, an organisation interested in these issues hosted a number of us to talk about these questions. And Professor was there with me, participating, as numbers of others were, in discussing the plight of the Rohingya people. I was better educated on these issues because of my presence, and I wanted to come to this point. If you go to the Cologne Declaration, you will find that it has statements about what is happening to the Rohingya, all of which I think in this audience you would endorse. But I found particularly a paper interestingly prepared by our then host Haseen of particular interest to me, because they spoke about what happened in Bosnia. And one of the points they were making was that, in simple words, Bosniaks as a nation have, since 1991, regardless of individual political, religious and other affiliations, documented uniquely and systematically in the best possible manner the genocide committed over them. Documentation was realised through the institutions as an immeasurable contribution to ensure that they were able to bring to account those who were responsible for destruction, murders and like matters. In other words, if you're going to go before an international court in the ways that have been described here, you're going to have to have documented all of the evidence in the most robust way. And if I were asked what could those who are here do that might help, it would be to play a part in helping to document the information that is going to be needed to bring these matters forward. I thank the Dakar University, I thank our Genocide Centre, I thank ActionAid because they've made it possible for me to be here. But what they did was they also made it possible for me to visit Cox's Bazar. You might think for a politician, this is a unique experience. It's not for me. My first visit to refugees started when I saw Afghans in Peshawar in the early 1980s. I visited the Vietnamese, whether they were in Malaysia, Hong Kong, Indonesia, fleeing after the change of regime there. I saw many of the Khmer over a long period of time. I visited Africa. I was responsible for putting in place the first programs to bring southern Sudanese to Australia when I'd visited the camp at Kakuma. I spent time particularly in the Balkans. I did visit Bosnia. I saw the Serbs who fled Croatia. I've had the opportunity of visiting extensively in the Middle East. I'd recently been in Turkey, in Jordan, in Lebanon, to see the people who had fled the horrific circumstances there. I visited the camps. I saw what there was to see. I have to tell you, none of them are ever very pleasant places to be. There is no way that people should be left in circumstances like that. And I found Cox's Bazar every bit as bad as anything you could see, notwithstanding the enormous effort that is being put in by well-meaning people to help those who have fled. When I saw something of the 50% of children that the judge referred to, and I looked into their eyes, I bonded with them, I saw them and listened to them, denied even there a full and effective education system for all the work that is being done. I'm taking home to show to all that I can the photographs of these magnificent children in this most depressing environment. But I wanted to share with you something of what I see as the hopelessness of their situation and what is likely if we don't address it. My first visit to a difficult political situation occurred in the 1980s. I went to Sri Lanka for the commemoration. They were a Commonwealth country. Bangladesh is a Commonwealth country. They had their independence and we were celebrating the 50th years of the, I think it was, of the Commonwealth Parliamentary Association. A great celebration, the rule of law, independence. I sat down with people of different backgrounds. Sinhalese, Tamils. When I sat down with the Tamil community, I heard about their concerns. Look, there had been circumstances that people would have said was colonial and terrible because the British used to divide and rule. They would advantage some over others. And the Tamils were seen to have been given an advantage in education and employment opportunities in government over the Sinhalese population. I mean, that's the background to it. And yet, at a very time when people could have sat down and constructively worked out the way in which if you have a different religion, you have different cultures, you have different interests, you can function effectively in a unitary state because you allow people to keep their heritage, to keep their religion, keep their language, and still function effectively within the state. And at the very time when they could have worked those issues out, established some municipal governance and allowed these differences to function effectively within the concept of a continuing nation, they refused to come to any agreement. It was possible. And within a short while, you had the establishment of the Tamil Tigers. and you know the tragic loss of life, the internal disputation that has gone on and on and on because those issues weren't addressed. Look, in part of my last life, publicly in Australia, I was asked to chair a panel that deals with religious freedom. It prompted me to look very closely at the international law, which all nations say they are party to. All nations. The Universal Declaration on Human Rights, to which every nation signed, is a starting point. I know there are some who say if you tried to get the world to sign up to a Universal Declaration on Human Rights today, it wouldn't be possible. There are some who do say that. You've got the International Covenant on Civil and Political Rights. And in Australia, we're party to it. And it guarantees freedom of thought and conscience and religion. It says that everyone shall have the right to freedom of thought, conscience and religion, and this right shall include the freedom to adopt a religion or belief of choice, individually or in community with others, in public or in private, and to manifest that religion in belief and in worship. And no one shall be subject to coercion which would impair this freedom to have or adopt that religion or belief of choice. Freedom to manifest one's religion and beliefs may be subject only to such limitations as are prescribed precisely by law and necessary to protect public safety, order, health and morals and fundamental rights and freedom of others. And in those states in which ethnic, religious and linguistic minorities exist, persons belonging to such minorities shall not be denied the right in community with other members of their group to enjoy their own culture, to profess and practice their own religion, or to use their own language. I make these points because they are part of the international framework of law that is of fundamental importance if we're going to be a civilised society. And in Australia, we don't regard ourselves as being perfect. We're not. There are always individuals who may occasion some difficulties with whatever values you adopt. But as a state, we affirm people's rights to make choice in relation to those matters. They can be part of a unitary state, but maintain their culture, maintain their language, maintain their religion. And I often say in Australia that diversity is a choice and a strength, because we've shown that people of every faith, all the world's cultures, can in fact live together. Most people don't understand that Australia has 25% of its population overseas born, and people who have come from all over the world. I say it's not perfect. It's not. But we've been able to demonstrate that it can be made to work. I think sometimes bicultural situations are more difficult and more challenging because people feel threatened. And that means I think there has to be a little more work. But I guess in coming to this seminar, I wanted to hijack it. I wanted you to understand the importance of the law. And all of the explanations that have been given are of fundamental importance for marshalling one of the weapons that we need to put together to produce change. I want to see the law used to get a better outcome so that the Rohingya can go home in safety and in dignity to be able to rebuild their own lives. When I spoke at Cologne, I took the opportunity to say to all of those present the international community has a responsibility to ensure that the regime in Burma changes its modus operandi. Now, I don't believe it's all that difficult. They hold themselves out to be a form of federation. There are differences. And I recognise that, you know, if you look at the Burmese having probably only 40% of the population, they've got 60% that represent diverse minorities. They're not Rohingya. A number of minorities, and they've got to be able to put in place a regime that is going to ensure that they're going to function as a state. I don't think, and I've said this, I've spent a lot of time in Africa, I don't think redrawing boundaries is going to be all that possible. I don't think we're able to go into Burma and split it up and say, well, we'll have a Rohingya state here and we'll have a Karen state there and break up the nation. I mean, I think there are sound political arguments for saying if you want to maintain a unitary state, you have to look at the models that enable you to provide for all people to function effectively, exercising all of the fundamental rights in which we agree. And I would hope that as well as the legal system being used, we will marshal the political states to put pressure on Burma to change. I think, and I got the clips which could reinforce the arguments I'm about to make, I would like to think that the world community that has recently visited Bangladesh through the Security Council has gone to Burma and has seen and heard from some of these people that they will have a desire to use the capacities and powers that they have to put pressure on that regime to change. In my view, sanctions effectively put in place universally have had some impact on North Korea. It's still working its way through, but we've got people to the table talking about these issues because sanctions have played a part. In relation to Iran, still working its way through. President Trump has different views about how these things might be addressed to his predecessor. But again, sanctions produced very significant change on major political questions because Iran realised that if it was going to be an open trading economy, it needed to engage with the rest of the world. My view is that the change that could occur if the UN were prepared to use sanctions in the same way could be substantial and would be quick to deliver outcomes. But you need to have Russia and China on board. And I know what the difficulties are. The Belt and Road strategy of China is about engaging with Burma, and so they see the regime as being important for their future trading into the Indian Ocean. I mean, I understand that's part of the psyche. I'm not against them achieving trading opportunities. I'm not against them being a powerful trading nation. I'd like to keep taking them on and working with them in relation to enhancing opportunities for their people and ours. And I would like to think the same would be the case in Burma. I mean, when you think about it, it's a state that needs to engage with the world community if it's going to be able to deliver for its own people all of the opportunities that we have seen others successfully achieve. And so I come to an occasion like this. I hope you will forgive me if I've hijacked the venue and the event. But I am strongly of the view that we should use the international law because it's one of the levers. But we ought not to forget that there are a multiplicity of leaders that need to be used. And for those children I saw, for the families I talked to, this matter needs to be resolved, and sooner rather than later. Thank you very much.
Thank you to the honorable guest of our seminar, and we are really delightful to have your insightful remarks, sir. Now I would request Professor Imtiaz Ahmed, Department of International Relations, Director of Center for Genocide Studies, CGS, University of Dhaka, to say a few words and moderate the question and answer session.
Yeah, thank you very much. No, I'm not going to say a few words. Better moderate and listen to some of the people who have come and have patiently heard three very eminent speakers, including Manzoor Bhai's opening remarks. So the house rule is please keep your questions short. Even if you want to put a statement, let the statement be, a kind of a question rather than a speech. So the more we have, we can let the three speakers come back and respond. If you have a particular person to address the question, please do mention. But when you begin, please do introduce yourself. And just for your information, the whole event is being live streamed as we speak. So the floor is open. Yes, Munir, go ahead. Yeah, there is a mic. No, mic is there.
Thank you.
Yeah.
This is Asif Munir. I work as a rights activist. I'll straight go to the questions, and perhaps this is to the two legal experts, but feel free for others as well. Just being a devil's advocate, because as we live stream, I'm sure Myanmar and their allies are also watching this and strategizing as well. What if the crime is committed in no man's land or neutral border territories, whether it's in terms of territorial jurisdiction, whether it's coercion, threat to life, what happens then? The other question is, can Myanmar file a petition against any kind of investigation or persecution in the name of state sovereignty? Thank you.
Ambassador Munshi, please. The mic.
Thank you, Professor Imtiaz. I have two questions. Number one is, of course, they all come out of my ignorance. I'm Munshi Faiz Ahmad, Chairman BIISS, Bangladesh Institute of International Strategic Studies. So the questions are, of course, born out of my ignorance, basically. But we know that the UN has, a few years ago, decided on this provision for a right to protection, R2P. Does that in any way give the ICC another avenue for jurisdiction in this regard? That is a question that, because I do not know, I ask. The other one is that came to my mind when I was listening to Honorable Philip Radok, MP, about the Chinese interest in this matter and BRI being the crux of the Chinese interest, as he was suggesting. But I wonder, whatever happens today and once these issues are resolved, China will continue to be China, India, and Russia. They will all continue to be important to Myanmar, whichever regime is there. So why should these countries feel that their interests are threatened if they are taking the current regime to task? Thank you.
Can we have one or two more before we come back to the panel? Anyone? Yeah, please. Introduce yourself and just wait for the mic. Just wait for the mic is there. Yeah.
I'll hold on to it.
Assalamu alaikum. I am Barrister Mahfuzur Rahman Milon. I am Advocate Supreme Court of Bangladesh and Executive Director of Justice House Foundation. We all know about mass killing of Rohingya people. So far I know that mass killing is still not being officially termed as genocide by United Nations. Rather, it is being termed as ethnic cleansing. My question is, why still now that mass killing is not officially being known or termed as genocide by United Nations? Thank you.
Let's go for one more and then we come back to the panel. Anyone from the back? Yes, please. Yeah, the mic.
Thank you to the honorable speakers for such informative presentations. I'm Tagbir Huda. I'm a research specialist at Bangladesh Legal Aid and Services Trust. I actually have two questions. The first is a rather generic question that may be answered by any of the panelists, and it is, what specific role can NGOs like BLAST play to build up the momentum in terms of building accountability of the actors with regard to the Rohingya crisis? Mr. Radak mentioned documentation. So is there anything more that we could do, or is there anything specific? Do we just record witness statements, or we are open to your suggestions? And secondly, it's a legal question, and it is, to what extent does the Bemba case help us with regard to the gender-based violence that are taking place in Myanmar with regards to the rape, a genocidal rape of Rohingya women? I was actually referred to this case by Ms. Pramila Patten, the UN Special Representative on Sexual Violence in Conflict. So I would want to know, because I believe this is the first case where the ICC recognized rape as a crime against humanity. It was against the former rebel militia leader, Jean-Pierre. So, thank you.
Ambassador Tariq Karim, the mic, please.
Tariq Karim, I'm a retired diplomat, now with the BRAC University. I have one comment and one question. My comment is, particularly having listened to all the distinguished speakers, that Bangladesh as a responsible member of the international community has a duty to uphold and further strengthen the regime of international law for crimes against humanity. We have ourselves conducted it because we, what I've described as the original sin, did not address the crimes against humanity in 1971. My question is, what if for any reason Bangladesh fails to meet the deadline of responding to the ICC? What will be the cost? And perhaps the distinguished panels can address that. Thank you.
Thank you. One more and then we come back to the panel. Brigadier Shakwat.
Thank you very much. I'm retired Brigadier Sakhawat Hussain. Just follow up the Ambassador Karim's statement. What are the implications that Bangladesh may have if it responds positively to the ICC? Perhaps Imtiaz will be able to tell it. How much Bangladesh would lose in international arena, or its diplomatic or financial matter, like countries like China, Japan, India, Russia, how they would take it. Thank you.
Okay, let's start with Vice Rifat. Rifat, you want to go first to respond? Can you bring a mic, one of the mic, please? Yeah. And then we go to Kate. Yeah.
Can I pick the questions randomly?
Please.
Yes. I'm grateful that the issue of R2P has been raised, and it figures happily prominently in the Dhaka Declaration. And what it says, the Dhaka Declaration says, is that recognizing the concept of responsibility to protect R2P that obliges the international community to protect refugees through multi-pronged interventions aimed inter alia at deterring occurrences of egregious international crimes like genocide, war crimes, ethnic cleansing, and crimes against humanity, and at holding the offending state to account. The Dhaka Declaration, which was the product of a two-day conference, I think there was a consensus arrived at that, at least in theory and within the permits of the law and international declaration, there are no barriers or there are no impediments to an affected state like Bangladesh operating on two levels in tandem, trying to achieve a resolution to a crisis through diplomatic means, while at the same time invoking the international community's duty under the circumstances to extend protection, not only at seeking a durable solution to the plight of the refugees, but at the same time, if need be, pursuing a judicial settlement of the dispute. So in theory, that is permissible under international law. Barrister Mahfuzur Rahman Milan, he said, why aren't we using the genocide word? The very concept of R2P is based on an understanding that in certain cases, a particular state will abdicate its responsibility to protect its own citizens within its own borders by resorting to egregious crimes and violence. And specifically, there is reference to the G word, genocide. And we've come to recognize that at the earlier forum in April. And R2P recognizes that it is specifically because of these crimes being committed that the burden of protecting victims of genocide and other heinous crimes, egregious crimes, to shift compulsorily, mandatorily to the international community. So the G word is being used. There's a question from Blast, what could be done with regard to the NGOs putting in their worth in the effort at documentation. I take you again to the Dhaka Declaration, and there at, I think, Declaration number 15, I think, point 15, there is mention of supporting the UN Special Rapporteur on Myanmar with regard to the Special Rapporteur's recommendation to establish a documentation structure to collect, map, and preserve evidence of human rights violations and abuses and testimony from refugees in Cox's Bazar, and call upon the UN General Assembly to implement the recommendation. On a personal note, our guest of honor referred to his experience in visiting the refugee camps in Hong Kong when thousands of Indo-Chinese refugees all over Southeast Asia were part of a comprehensive plan of action in seeking a durable solution to their plight. And part of the comprehensive plan of action was the role of the UNHCR that was recognized exceptionally by states all around the region to engage in status determination of the individuals as refugees or not. And it was through that process that effective oral and documentary evidence was collected of the sustained continuous level of persecution of individuals in Vietnam. We may not, at this point in time, want to go into the mechanism of status determination, but we can take a leaf from the UNHCR's experience as to how to collect this information by making it clear to our constituents, as it were, the refugees here, that it's being collected for a purpose, to probably to facilitate their return in safety and dignity, and also to hold Myanmar accountable. I leave it at that.
Kate?
Thank you. I'm kind of glad someone asked the no man's land question, but also scared by it. It's really the crux of one of the issues with deportation, and one that has been discussed a lot in academic commentary on the application. I think one of the ways to get around it is very practical. You know, many borders have a no man's land, right? You get to the border, you show your passport, you get into no man's land, you get to the next border post, and then you cross. And I think to start talking about crossing an international border as being that first point of crossing is going to cause a lot of complications legally for jurisdiction over these crimes. And some amicus have already dealt with this by saying it's entry into the next state. And actually the wording of the elements of crime where they say to another state would effectively deal with that. I think we have to be practical about these things. If you're talking about the crimes themselves being committed in no man's land, then that's a different issue. And I think then there's a lot of other jurisdictional factors at play. It depends how many elements of the crime, who the people were, what their nationality was, and therefore territorial jurisdiction might not have such a significant role. I mean, this is really a similar issue with the high seas, and that issue is ordinarily dealt with by, you know, the nationality of the boat, the nationality of the perpetrators. So it really depends on the circumstances. But yeah, absolutely, this is going to be something that they're going to probably have to deal with. Your second question on Myanmar filing a petition, it's an interesting question in terms of process, because there is effectively no process set out under the rules of procedure and evidence. But normally at the preliminary examination, investigation stage, confirmation stage, trial stage, the affected state has the right to make submissions. So I don't see why Myanmar couldn't file a submission in this case. They can only get rejected by the court as being premature, but they are an affected state, and if they wanted to file submissions, I expect that they probably could. On the R2P point, I think you've already covered it, but I just would want to say in terms of the ICC acting on the notion of R2P, there's just no jurisdictional basis for them to do so. I mean, it's as the Honourable Justice set out, it's really Security Council referral, state party or state referral, and that's it. In terms of the UN not recognising genocide, again, you've already commented on this, but I wanted to add, and I'm a consultant with the UN, I'm not here in my capacity with the UN, and I haven't worked with them while they've been deliberating over this, but I know from experience that proving genocide is a very difficult thing to do. What makes genocide genocide is the special intent of the perpetrator. Yes, there have been loads of acts committed which constitute genocidal acts, and they're not just mass killings, sexual and gender-based violence, it's torture, it's a range of other acts. But to prove that someone had the intent to destroy that group or in whole or in part is extremely difficult. And it's something that many prosecutors at the international level have failed to do in circumstances which are not dissimilar from what we're seeing now. So I think there's caution in that respect. I also think, though, and this is going to a point that you made about R2P and genocide, I would argue that it's not just genocide that compels states to act, that they should be compelled when it's a crime against humanity. I mean, labelling this as genocide or not, this is, nearly 1 million people being pushed across the border. If states are not going to act on that, then they're not going to act on anything. The roles sorry I'm taking up a lot of time here, but the role NGOs play, I think there's a lot of things that can be done, and it depends on your expertise and what you can really bring to the collective advocacy that's going on. And I think that's in the form of if you have legal expertise, making amicus submissions to the court, making filings to the court. It's one thing that I think can never go to waste is finding creative advocacy strategies with states and pressuring them to do something, pressuring them to act, because that is really where the problem lies at the moment. I would caution telling NGOs to go out and do documentation work. There are many, many, many organisations in Cox's Bazar doing exactly that, stepping over each other to get to the victims. There are some victims that are being interviewed 5, 10, tens of times. And there are repercussions to doing that. Yes, it's good to document the evidence. It's really important that we get that while the evidence is fresh and we don't lose it. But, you know, there's this principle of do no harm and not re-traumatising victims through that process. There is also the problem of having masses of evidence from the same victim which eventually end up in a criminal process before the court. So I saw this in cases I worked on where you would have multiple statements from the same victim, and any discrepancy between those statements can be used to discredit their testimony. And so that in itself was problematic. So unless that's your complete modus operandi, unless that you're an expert in that, then I would really caution against going out and doing that. I'll talk about Bemba because I think probably no one else on the panel will. Yeah, it's great that the court, after many stumbling blocks, finally has a case on sexual and gender-based violence. They've developed some jurisprudence, and that jurisprudence will no doubt be helpful in future cases, particularly for accountability and who should be held accountable. I mean, Bemba wasn't always, you know, a perpetrator of sexual violence, but he's been held accountable as a commander, and I think those links are often hard to make. So there should be some useful lessons and useful jurisprudence in there. I'm going to leave the political questions to Mr. Ruddock.
Fancy that. I think there are only two, and the one that was just addressed by Kate, let me just say, in my judgment, the issue of collecting information that might be used has to be undertaken in a coordinated way. I mean, this is in Bangladesh. I would have thought the government would be in a position in providing access, particularly to Cox's Bazar, to organisations that may be intent on doing that, to coordinate it, to see that it happens in a appropriated, structured way. The information that I had in relation to Bosnia, to give you some idea, the prosecutor's office heard over 10,000 people for the purposes of gathering intelligence on crimes committed. Over 5,000 witnesses testified before the ICTY. And in essence, unless you have evidence, you don't get to court. That's the reality. And so I guess I understand the difficulties you raise, and particularly in relation to multiple interviews and possibility of people getting a story somewhat different and what that might mean. I mean, all of that has to be, I think, understood as one of the difficulties you've got, and even more why, if we're wanting to put pressure on Burma to resolve these issues and the prospect of people being indicted for these sorts of crimes, it needs to be pursued in order to get a better outcome. Now, I don't know how Bangladesh, the government of Bangladesh feels about that, but I think they have to play a role in ensuring that it's done in a structured and coordinated way. In relation to the UN Security Council, I know nothing. I just read. I was reading an article in the Gulf Times. I'm sure you're all readers of the Gulf Times. I read some comments because it was just indicating that the UN Security Council has a role to play. And I think they recognise they have a role. That's why they were here, and that's why they went to Burma. But we need to recognise that, you know, they have 5 permanent members, and unless you've got the 5 permanent members all on side, you don't get an outcome. The other 10 don't matter. It's the 5 permanent members. So you've got to get the United States, Britain, France, and you might get them relatively easily. But you've got to have Russia and China. And in the report I was reading, this was a comment from the Chinese representative. This is a very complicated issue. and it's related with history, with ethnicity, with religions. This was Chinese Deputy UN Ambassador Wu Heitu. Asked a question about whether China and Russia were preventing the Council from considering a resolution on Myanmar. There is no easy answer, but if we all work together, I think we can find a way. Well, I think we need to encourage them to find a way. Council is united on travelling to the region. Diplomats said they expect Myanmar ally, China and Russia, both veto-wielding powers on the Council, to resist any push for a stronger Council action, such as sanctions or a referral of the situation to the International Criminal Court. The Russian ambassador, we don't have a magic solution, he told reporters in response to a question about whether it would consider it without reference. The issue is still for us to promote bilateral ways to resolve this issue if we try to convince governments to engage in constructive negotiations. So, you know, we're at a point where we know there are hesitancies on China and Russia being involved. It's expressed in the words of their ambassadors. I think that the extent to which we, as part of the international community, can help to persuade them that this is an issue that they need to be involved in, that it can be usefully pursued. Part of the problem is you've got politics being played and people thinking they can get an advantage over one over the other. You know, I mean, I know how these things work, but sometimes when the issues become so important, the politics gets put to one side. We need to make sure that this is one of those issues that is so important that they'll put the politics to one side.
Could I make an additional point here? Of course.
We'll come back. We'll come back, yeah. Yes, Dr. Mint? The mic, please. Let's go for the second round of questions now.
I'm Lamint, I'm Dr. Lamint. I'm based in Australia. I'm a professor, and I'm an Australian with a Rohingya background. My question is to that, you know, Security Council is paralyzed, okay? So it will take a long time to get a resolution. But in the event of paralysis of Security Council, General Assembly has a upper hand rule. In an exceptional situation, it happens once in 1950 that General Assembly called Uniting for Peace in the event of Korean Civil War, because numbers of people who got slaughtered is in quite horrendous way. Our situation now is no different than what's happened during the Korean Civil War or any other conflict zones. So with the initiatives of Bangladesh is a member of OIC, Organizations of Islamic Conference, and Organization of Islamic Conference itself, can propose this kind of solution. And my question is directly put to Justice Saeed Rifat Ahmed, whether such a kind of precedent is available or whether that kind of evidence can be applied.
Next. Okay. Anyone? I'll come back. I've heard that.
I'm Mohammad
Yes.
Ibrahim Mollik. I'm from sharabangla.net. I'm a reporter of the newspaper. My question is to Kate Binger-Soren. And if we want to let the ICC prosecutors understand that the Myanmar is committing crime against humanity, do you have enough documents that can prove our allegation? And what kinds of documents do we need to present here? And as you worked 40 rights, and you may know well about documentation, because it is discussed that documentation is very important to prove our allegation. Thank you.
Sure. Do we have any more hands? No more? Sure? Okay. Please. Kate, you want to go first?
Thank you. So on documentation, it's an interesting question and I think a difficult one in this context. Obviously, access. Firstly, I'll talk about the types of documentation. So, you know, there's various different types. I mean, there's going to be documentation on, you know, background documentation on like citizenships and verification cards and things that people have brought with them into Bangladesh, and all of that will be useful. Some of the documentation that's most useful in these types of prosecutions are official documents from government authorities. So in the Yugoslavia context, we relied on a lot of internal official documents that we were able to access largely through law enforcement operations that we were able to carry out because we had state cooperation to a certain extent, and because we had insider witnesses. So those are witnesses that were willing to provide documentation that they had access to because of their role as a government official or a military official or whatnot. That is obviously going to be extremely difficult in this context because, you know, as you know, Myanmar doesn't allow access to investigators, to the UN Special Rapporteur, or to anyone that's trying to document these crimes. So the extent to which that might be available at a later date is unclear as yet. You know, we might be talking a considerable amount of time or not. It just really depends on how the situation pans out. But that being said, it is going to be very important, or can be very important particularly for proving the responsibility of more senior officials or more senior networks in terms of their accountability when they weren't on the ground and you don't have eyewitnesses that can identify who they were.
Your question tied in completely with the provisions in Article 33(1) of the UN Charter of the range of mechanisms available for passive or peaceful settlement of disputes. Needless to say, Bangladesh is still atop a very high moral ground here as of August in terms of granting sanctuary, albeit declarately, temporarily, to these hundreds and thousands of refugees. But at the end of the day, and I suppose that's the sole purpose of a seminar as this, is that, you know, international law is notorious for running low on efficacious or effective mechanisms of enforcement. Very few mechanisms are available. I referred to one such mechanism under the UN Charter, where the UN Security Council can step in under exceptional circumstances. The ICC statute also recognizes the UN Security Council's initiative at this end. So, you know, in terms of enforcing or bringing about change, durable solutions, or I think if you want to take resort to international law, then your avenues are fairly limited. It's either the UN Security Council and now this opportunity that has been, you know, given us in a platter to invoke the ICC's jurisdiction. But the other avenues, collectively, they can play a role to facilitate a greater adherence to international law by Myanmar, and maybe a facilitator also of a regime change, as it were, in its most, you know, favorable sense, as mentioned by our guest of honor. Yes, both avenues can be perceived in tandem, I think.
Philip, we still have one more. Shahidul Alam.
Hi, I'm Shahidul Alam, a photographer and a writer. I work for an independent media organization called DRIC. Thank you very much for organizing it. It was very, very necessary and timely. My concern follows up from what Justice Rifat has just said. Here we are talking about the intricacies and the niceties and the complications of international law. At the end of the day, there are people out there suffering. Their need is now. and something has to be done. You did mention the complications of documentation, and I recognize that. But I think the documentation is not simply because the international legal community needs it. I think people need it. I think the stories need to be told. I think we need somehow to get people on board. And public opinion is something that we've not really talked about, but I think is a powerful equation in this, including when it comes to legal processes, because whether we agree or not, public opinion does exert pressure even upon those structures. I think one of the things that has to happen is we need to be able to sway public opinion in our neighboring countries. These are countries we will have to continue to work with regardless of what happens to the Rohingyas. I think we also need to be able to find ways in which within Myanmar we're able to get some of the information out, because I suspect part of the reason why they're able to get away with this is because of the perceptions that have been created within the country which have nothing to do with reality. And unless we're able to change those things, it'll be quite crucial. Another thing that may have long-term repercussions is the fact that recently Myanmar and Israel have now entered this agreement where they will effectively be doctoring each other's educational material. So we are looking at something that happens here in Bangladesh as well, sadly, where long-term information of the public is manipulated by states in their particular interests. And that, I think, is something that civil society can play a very important role in.
We have one. Oh, sorry, go ahead, sorry.
Thank you very much. I'm Phaedra Morris. I'm head of cooperation at the Canadian High Commission and Chargé d'Affaires. I didn't want to speak earlier because I get your point about asking questions, but I did want to emphasize that there are ongoing coordinated efforts on documentation, and it is very important that goodwill and efforts by those who want to engage do not overlap with these. So this point has been made by the panel, but I would really like to emphasize that the re-victimization or re-traumatization of individuals is a strong concern currently, that there are larger efforts, that the report of the fact-finding mission of the Office of the High Commissioner on Human Rights will be coming out this summer with recommendations. And so there is a big difference between testimony and evidence. And so we really have to keep this in mind. Having said that, there is a substantial role for civil society in advocacy, such as my colleague just mentioned. We really need to ensure the story is coming out, and that doesn't have to be individuals, and it doesn't have to be their trauma. We have seen so much of this, but continuing to advocate here in Bangladesh as well as international for accountability, for a response, and for the global community to recognize it's a shared responsibility for the crisis. But I just wanted to emphasize that point. Thanks.
Thank you. We have Mr. Hassan Arif first, former Attorney General.
Thank you, Imtiaz. My actually is not a question. It's more in the nature of comments after listening to the papers presented by two distinguished guests and the observations and comments by Honorable Philip. It appears that if you go at the root of the application, you'll find that the prosecutor has made the application under Regulation 46.3. That means she was aware that Myanmar is not a party to the to the statute, and so what other avenues could be explored to bring Myanmar within jurisdiction of ICC. And it is also significant that she made the request under Article 19, sub-article 3 of the statute, which means that when the prosecutor has evidence, and it is up to her, that she can make a request for a pre-trial chamber ruling as to jurisdiction. And Article 19.3 takes us to Article 13C, which means that one of the party, or which describes a situation where one of the party to the crisis is not a member of the ICC. And then 13C takes us again to Article 15, sub-Article 3. It is significant that Article 19, sub-Article 3 also makes way for victims to submit observations. The observation that the pre-trial chamber has asked for from Bangladesh. And 15C also has room for victims. So it can be said that the prosecutor was very much conscious about the problems he is going to face in getting a ruling from the ICC over Myanmar's, though she's not a member of the statute, but Bangladesh is. And it has been elaborately dealt with by Justice Rifat in his paper, and also by Madam Kate in her presentation. So my feeling is that, and our urge will be to the government not to miss the deadline, as Professor Karim has expressed his anxiety that if the Bangladesh government misses the deadline, what will be the cost? So my observation will be that pursuing bilateral treaty and ICC ruling together with international bodies, including UN Security Council, where we have problem which has been dealt with, that other factors may be intervening factors in using Security Council, the General Assembly, to bring Burmese regime to ensure repatriation are in fact not in conflict with each other, but are modalities for achieving just resolution of Rohingya refugee crisis. We want total repatriation and rehabilitation. Then pursuing all three modes are not derogatory. They are or incompatible to each other. That one, we have to give up one if we pursue one. We can pursue, rather taken together, these modes are more effective in pursuing Burmese regime to repatriation and rehabilitation. News item in several daily journals reported that Parliamentary Standing Committee on Foreign Affairs expressed dissatisfaction about progress of repatriation under the bilateral treaty, and that it has many flaws, and one of such is any time limit. And that means Myanmar has another 100 years for repatriation. The Foreign Ministry is reported to have said that and admitted that international presence is being sought to persuade Burmese regime. The report justifies the move before the ICC that we cannot solely rely on bilateral treaty with Myanmar. The government is urged to submit the affirmative observation to pre-trial chamber 1 of the ICC. In this respect, it is also important that victims may also make a representation to the ICC under this very rule. To ensure on the ground, it is not enough that they are repatriated. The atmosphere there must be conducive and congenial so that they may go back to an atmosphere where they can live in security, peace, and confidence. To ensure on the ground conducive and congenial situation for safe and secure rehabilitation in Rakhine, it may be explored whether UN peacekeeping forces could be put in place for several years to come, maybe for 10 years or more. And in order to give an atmosphere of congeniality, the PK force may be drawn from SAARC and ASEAN countries. Then local law enforcing agencies may be raised from among Rohingya population, initially under UNPKF and the Burmese government in joint supervision to ensure confidence among the repatriated people. Some organizations need to take up Rohingya victims' participation in the pre-trial chamber jurisdiction ruling, as pointed out by representative of BLAST. There are ample opportunity on the part of NGOs to work on behalf of the victim. And another item, the forced babies. We have read in the newspaper about the forced babies. Then construction of homes and shelter for babies in and around Rohingya locality in Rakhine with international financial assistance. Charitable organizations who are running such home and shelter may come forward to maintain and run such homes and shelter. Preferably, those organizations come from ASEAN and SAARC countries. That would ensure ethnic and cultural context close and similar to that of the home. And in respect of what Honorable Philip said about, though it's a harsh word, regime change, that means the process of democratization in Burma may be facilitated by interaction with the Burmese civil society for democratization, deregimentation, and demilitarization of Myanmar. And local Rakhine people must also be taken on board, contributing towards creating a congenial neighborhood in the ground. It is possible initially, maybe through the PKF, and that is important because if the local people think that the Rohingyas have been thrusted upon them, then lasting peace will not be possible. So their participation is necessary so that ultimately the Rohingya get integrated in the Rakhine. And if we go through the history of Arakan, we'll see that the Rohingyas are the son of the soil, because Arakan had Chittagong at some point of time, the monarchy of Arakan, Chittagong, as part of their monarchy kingdom. Then after the Second World War, Arakan was taken by the British, and then when in 48 Burma was given independence, Arakan was given back to Burma. So it is something like that. If Sylhet goes back to Assam, Assam cannot say that we want the land, but we don't want the people because they are intruder. No, if you take the land, you have to take the people with you. So my feeling is this, that the first and foremost is on the part of the government to respond to the ruling that the ICC has asked for. And we are running short of time. And in order to fill up the gap, BLAST and other organizations may come up for taking the victims' representation and opinion to the ICC. Thank you very much.
Thank you. Yes, please. The mic. Can we have the mic there? Yeah, sure.
Hi, I'm Eugene Lee. I'm a law student working as a legal intern at BLAST. My question was that if under the principles of UN Charter, the responsibility to hold the country accountable and to deter future acts fall on the two-party states, two affected states, as well as the international community, on whom does the responsibility of rehabilitation for the victims fall under the UN Charter if we are all responsible for right to protection of every individual?
Okay, I guess no more questions. Last minute burning question? No? Okay. Kate, you want to go first? The mic, please.
That's a tough question. The responsibility for, if you're talking rehabilitation, meaning the Rohingya get to return home, go back to their land, have equal rights, that's on Myanmar. It's their territory, they have the responsibility to make that happen. I'm not as familiar with the concept of R2P as I think the Honourable Justice is, and so he might want to comment further on that. But my understanding of R2P is that it is really about the responsibility of states to act when there is such a situation, where there is to intervene, to stop it, prevent it from happening, and return it to what should be the status quo, and that wouldn't give rise to them having an obligation to rehabilitate the community back in the location where they are. I could be wrong on that, so yeah, but my understanding is that's Myanmar's responsibility. It's their territory.
Yes, the UN agency that immediately comes to mind that has the structural and the legal ability and the mandate to engage in such rehabilitation activities would be the UN High Commissioner for Refugees. And it has done so successfully in the past, and there's a glorious example of that having been achieved in the 80s and the 90s through the Comprehensive Plan of Action with regard to Indo-Chinese refugees. Yes, there was initially a status determination, a region-wide status determination process at work, but at the end of the day, there were hundreds and thousands of asylum seekers who were not screened in as refugees entitled to resettlement in third countries. So they had to go back, preferably voluntarily. Many went back involuntarily. However, what was done at the end was the UNHCR, with the cooperation of ASEAN, with Vietnam, of course, and mainly the European Union, worked out a rehabilitation scheme which was sustainable, which was long drawn, but was sustainable to ensure that the returnees would not face persecution and discrimination on return, and that their rehabilitation would effectively lead to reintegration. So, and I think there's a New York Declaration on Comprehensive Refugee Response Framework adopted by the UN General Assembly in September 2016, which, if I'm not mistaken, identifies the UNHCR as the prime agency capable of achieving this under the circumstances.
Philip.
Thank you. My Canadian friend? Is there an address? Is there an address? Well, I wasn't aware that Canada was coordinating the collection of the information of all of the people at Cox's Bazar, and I welcomed the news that I received. I may be naive, I hadn't heard it before, and maybe others hadn't heard it before, and I'm asking for a contact point so we know where to collect the information.
Sorry for the miscommunication. I was saying if there is coordination. So you have through the Office of the High Commissioner for Human Rights, the fact-finding mission of which a recommendation structure is going to occur. The work that is
Did you say is going? Did you say is going?
Can you have the mic? Oops.
So those larger organizations and funded organizations are meeting in coordination to ensure that what is looking at the processes that are currently ongoing to see if they would qualify to be considered of the level that would be required. If not, there's discussion on the capacity building that needs to occur for institutions that will and have been looked at to collect information, but that is required before contact with a vulnerable population. So there has been a lot of well-meaning efforts that have occurred that we, at this point as an international community and in discussion with organizations that operate with the community in Cox's Bazar as part of the Rohingya response, are talking for the guidelines that are established. So there are specific guidelines, and you, all of the panel, would be much more aware than I, but that we all are aware of, on contact with such individuals for these processes. So we are highly recommending that those institutions that this is not their area of expertise, of which they do not have the capacity that is deemed to be able to collect and document in a way that would reach international standards, then focus their efforts on advocacy. There are so many gaps in the response in which areas can happen. But the collection of evidence, which is very different than stories and testimonies that could be used for information, we have to be very cautious. And there is broad agreement on this, that this population is one that already is a traumatized one. It is one where women's testimony, and men's, but women's testimony of how they have been systematically abused has been repeated and repeated and written down in different forums, and not in a way that will stand up in a court of law. And so we have to ensure that we look at what will be needed. Accountability is critical. I think everyone is in this room here is in full agreement that accountability is critical. But there are organizations and partners here who this is what keeps us up at night and has since August 25th and before, since October 16th, on how do we ensure that what is collected is done in a way that will stand up in the court of law and not create a re-victimization of a population whose resilience has been amazing, but we should not continue to test.
When I was a minister, and I had bureaucrats like you appearing before me, I would say, you've got a great story, I understand all of the difficulties, and I'm now asking you to find me a way through the mire so that we get an outcome. And the point I was making in my address is that we need to have a determination to get the evidence appropriate for pursuing the prosecutions, and if we don't, we will have failed. And I want to know who is coordinating it, who is pulling it all together to ensure that the difficulties that you and others have identified does not occur. And so I still ask the question, if it's the international community that's doing it, if there's a particular agency that's doing it, that is the coordinating body responsible that's collecting all of the testimony, I'd like to know who they are. Anyway.
I would highly recommend contacting the Office of the Human Rights of the High Commissioner. And just to note, when you mentioned bureaucrats like myself, I can say that Canada's recent announcement of our strategy and our response for Myanmar and Bangladesh to this crisis highlights the ICC, highlights that Canada will be continuing to strongly advocate in this area. I think that does not mean that any of us can rest on our laurels, but I do believe that that this issue is not forgotten, that this issue is on the forefront of many of our international priorities. And so what we can do to contribute to this effort is we welcome your advice as well.
I think we'll talk later. I go to the point. There may be the appropriate international agency. I think everybody needs to walk out of this room saying they know who they're going to talk to provide the information that they are collecting, because they're well-meaning, they are concerned, they want to know. Can I just deal with the other issues that really came through in relation to the two questions that we received, which I think were related in relation to returns? The issue of return is particularly difficult. When I was sitting down with people yesterday at Cox's Bazar, they were telling me of what they left. And what they left is not what is there now. Their homes have been destroyed. Their farms have been lost to them. Others have acquired them. And the expectation that people will be able to go home and rebuild their lives in those circumstances is particularly difficult. And yet I know the Rohingya want to be able to go home. That is their desire. But they wish to be able to do so in situations of safety and security and dignity, and when they can get access to what was theirs. Now, I don't know how we're going to get there. I think it has become particularly difficult. But when you know that the people at Cox's Bazar, and we're talking of in excess of 1 million people in a very confined area where they cannot survive long term, there has to be a solution. And unless you're going to dedicate substantial areas of Bangladesh that have not been occupied to enable people to start farms and create businesses and generate new lives, it's not going to work. You can't just leave them as they are in terms of all of the information that's been given to me about the nature of the site that they are now in, particularly with the seasonal changes that you know far more about than I do. I was very familiar with the Comprehensive Plan of Action. The minister who implemented it in Australia did so because we had reached a point where we were taking everybody who got on a boat from Vietnam. The numbers were impossible to get resettled because they were in Hong Kong, they were in Indonesia, they were in Malaysia, Pulau Bedong, I went there. And in the end, if you were going to get it resolved, there had to be a plan of action to sort out who were really refugees, and 90% weren't. 90% weren't. If I can tell you a story, I went to see that when people returned to Vietnam, they went back with safety and dignity. I wanted to satisfy myself that that was in fact occurring. And I can tell you this story. I went into the port city of Haiphong to meet a young man who had left on a boat for Hong Kong with his wife, and the child was left with their grandparents. They didn't want to take the child on the boat, so mum and dad looked after their grandchild. That's fine. Who was dad? He was the director of a local business, the president of the local branch of the Communist Party, living in a lovely mansion where the grandchild was being looked after, but the son and daughter-in-law wanted to go to the United States to start a new life. And the view was they could go home with safety, and they obviously could. But that's not what we're talking about. A comprehensive plan of action implemented by the UN will probably find that 99% of these people are genuinely refugees. That's what I suspect. And so the difficulty is that if you've got no place for them to stay, no place where they can go elsewhere and be resettled. I haven't heard the international community bowling up and saying we're going to take 1 million people. Thank you very much. The circumstances have to be created where they're able to go home in safety, in dignity, with their properties secured, with future governance arrangements. I think there may be a need for an international peacekeeping force. I mean, I've seen those forces in other parts of the world. They can work modestly. I think you need to have governance arrangements, particularly with policing, that involves the whole community, and that means that if you're in Rakhine State, you would have a reasonable number of Rohingya police, along with others, to ensure people's safety and security. I mean, there are a lot of things that have to be thought through. I don't pretend to be on top of what it is that you would need to do, but I know it is extraordinarily difficult and demanding. But I think, and I hope, that all of the pressure that can be created by looking at the prospects of holding the people who've done this accountable through the international judicial system, coupled with the other pressure that we can put on states, will produce an outcome where people can go home in safety and rebuild their lives. And I was asking this question: what is being spent now by the international community in Cox's Bazar? And how much more would you need to put in place to fund returns, resettlement, and to provide reasonable security? And I suspect that probably the difference may be not as significant as you would think. But the outcome needs to be one that the international community presses for and seeks to achieve.
Thank you very much. No, I think we have, I'm sorry, don't have the time, run of time, but you can, on individual basis, probably after this event, you can talk to some of the speakers. As a moderator, just a couple of things I want to flag so that we keep certain things in perspective. One thing is clear, listening to the three speakers, that the legal issue is critical, but then there is more than legal issues. There are political issues, there are issues of economic issues, not to mention the issue of morality and ethics. That should not be in any way undermined or discouraged, because a modern state gets reproduced on the basis of morality and ethics. If there is no morality and ethics, the state collapses. So, yes, the legal issue is vital, and I think this particular session that we had clearly you can see the difficulties that will be there, but I think there are enough, what I would say, minds which can work, which would make Myanmar accountable. The second issue that I want to focus on bringing Myanmar, the focus ought to be Myanmar. I think that is what I sometimes get worried. The focus is increasingly, on the Rohingya refugees and then on Bangladesh. The focus ought to be Myanmar. And when I say focus ought to be on Myanmar, we would know that they are serious in repatriation the moment they change certain rules and bring new laws, either through bills or through presidential statement in some form. If that is not there, then I think this very discussion, and I've been saying to our government from day one, that are they talking about new laws? If they're not talking about new laws, then it's not going to work. Simple as that. Now that brings to the issue of bilateralism and the issue of multilateralism or this international, the exercise that we hopefully will be facing. And from day one, I've been saying again that bilateralism, one can understand why the government is working on bilateralism, and I have no problems with that. But the issue is different from the 70s and the 90s. This is not the first time that we have the Rohingya exodus. We had in the 70s and the 90s. Myself was involved very much in the 90s. This one is different because there is enough credible evidence that a genocide or crime against humanity or ethnic cleansing took place this time. This evidence was lacking in the 70s and the 90s. And those who are worried about the evidence, I can only say, from day one, the government and its agencies were absolutely conscious of this issue of evidence. And you will get that by the very fact that this time each and every member has been digitalized. It's a record, it's something, a data set to see. When they arrived, how they arrived, in what condition they arrived, in which village they arrived, what is the neighborhood, is there. So this is not the 70s and the 90s. Now, and I've been telling also to the government that even if you resolve this issue bilaterally tomorrow, even if they go back, the issue of crime against humanity and genocide, ethnic cleansing will not go away. That's the issue. It has nothing to do with Bangladesh and Myanmar this time. It has to do with certain groups in the military and their collaborators committing crime against humanity or genocide and ethnic. That's the issue. It has nothing to do with Myanmar. I have a good number of friends in Myanmar. I've been meeting them in Bangkok. I've recently met them in Beijing. I'm meeting them in several places, and they all agree. So it's not the whole of Myanmar. There are people, even in Myanmar, who understands what has been done cannot reproduce the Myanmar state. And they need to go back to their own civilization. Each and every state has, gets reproduced because of their civilizational strength. The civilizational strength that Myanmar had is no longer there. That's the issue. So they are also, puzzled by this whole issue. So the point is, you can solve it bilateralism, and you can easily see that how they have changed from day one. If you keep track, and as we have been keeping track from day one, and you have seen day before yesterday in the Shangri-La dialogue, the National Security Advisor saying, we'll take back all 700,000. Look at the changes. Because they can feel the pressure that is coming up. But this pressure ought to be built. The focus ought to be Myanmar. That's the issue. Because an archetype has developed in Myanmar of fear, of anger, of vengeance over the years. It's not just yesterday. Over the years, in fact. And you can see, from the 60s onward, 62, altogether. And you can, literally point out, there are enough number of books that have come up narrating that particular story. Philip has rightly pointed out about the issue of sanctions. Some of our government officials have been also openly talking about that sanctions is one way of building pressure. Now let's take China, for example. Nobody talked about India, though, for some reason. That was quite interesting. But you can see India has also changed. It's now talking openly that ought to be a solution. I think the policymakers, and I talk this on a personal level, policymakers of Narendra Modi failed him this time. He could have emerged as a world leader. They literally failed him. Because Delhi has an excellent relationship with Bangladesh. I wish Tariq Karim was here because he was the High Commissioner working on this very hard. And they also have a very good relationship with Aung San Suu Kyi. Delhi was in a position to bring both of them, but they tried to compete with China. How can you do that financially, economically at this point? And now they understood that Myanmar is now more dependent on China than it was before. That's, I would say, the failure. And there are a good number of friends I have in MEA, and I told them flatly that you have failed Narendra Modi. Now, bringing on China, the very fact, and this is, I think somebody, I think Philip pointed out on the Belt Road Initiative, the very fact that they have a Belt Road Initiative will actually bring them to the point of pressurizing Myanmar. Because you cannot have an investment of that scale. It's a huge investment, not to mention also in Bangladesh, but also in Myanmar, of a kind to a state where the international community is saying that it has committed genocide, a crime against humanity, etc., etc. So the very fact that they have this One Belt, One Road initiative, it's only that how they operate bit differently. Yes, they have been putting all the restrictions at the UN. But the moment the foreign minister of China comes to Dhaka and goes to Yangon, says we have a three-phase strategy. The first phase is to cessation of hostility. You may debate on that. Second is repatriation. Third, go into the root cause and solve the problem once and for all. Look at the three-phase and look at Kofi Annan Commission's report and look at our Prime Minister's 5-point approach. There's a consensus on that. So I would think that we need to work on that, and I've been telling our government, the PM should visit both Delhi and Beijing more frequently, and particularly on this issue. I hope that will come in the future. But the fact that we have the political and the geopolitics involved, one can easily see that we need to work hard. I don't think it's two permanent members there. I think it's in one. Russia is just behind China. It's not two members opposing. It's only one. If one says yes, I'm sure Putin will also join in. But on that also, I think one of my suggestions would be that the Bangladesh government should invite Mr. Putin to visit Dhaka. That can change things as well. The UN General Assembly is an approach that has been highlighted several times by many important people. Yes, ICC would be one key domain that we'll be looking at, but I'm sure Bangladesh government would be working very seriously on the General Assembly. Finally, at the end of the day, Bangladesh, as you know, in '71 faced a genocide and had 10 million refugees. This is a country which cannot stop refugees coming in. Can never do that. And in last 6 months, I think you have seen that literally you have more than Bhutan, literally more than Bhutan getting established inside Bangladesh. Well, Bhutan's population is less than 800,000. We have 1.1 million people. But Bhutan took 50,000 years to become Bhutan. This got established only in 3 months. But I would request those who have not visited, please go and visit. You will see that the Bangladeshis, both the GO and the NGO partnership, we have what you call, in terms of disaster management, I think we have the finest non-governmental domain. And we can be proud of that. And it has worked absolutely superb. And there are people who have been working tirelessly there, made something which is something to see. But as all the speakers have pointed out, it cannot continue forever. It has to come to an end. Now, so at the end of the day, when we look into this whole issue of Rohingya refugees, I believe it's an issue that should be looked at, that what each individual can do personally. Those who are in the government can do in one way. Those who are in civil society can do it. Those in the media can do. I've been telling the media all this, please don't focus Bangladesh. You need to focus Myanmar. Try to get as much information from Myanmar. Who were the people involved? We already know some of the, military officers. Why don't you, flag them? Put their pictures on. But somehow, I'm not trying to say I'm critical of media, but the media gaze is always Bangladesh. There has to be a critical gaze, a serious gaze of the media on Myanmar. So each and every individual, I think there was a question that what NGOs can do. X number of things. It's an issue, as I said, it's an issue of how do you reproduce yourself and the civilization together. And once we get that understanding, we can see the legality, the politics, the economics, morality, all are involved and all are important. With that few words, let me thank all of you, but we have an official vote of thanks. And let me now welcome Farah, the co-sponsor and co-organizer of this particular event. Farah, please, for the vote of thanks.
Thank you, Dr. Imtiaz. It's the guest of honor, Mr. Philippe Ruddock, our special guest, Honorable Justice Rifat Ahmed, who I prefer to call my friend Rifat, but anyway, formalities. Ms. Kate Winners-Warren, our respected colleague and counterparts, fellow guests, everyone who is here, thank you very much. On behalf of the three organizations, Mr. Manzoor Hassan, OBE, Professor Imtiaz Ahmed, and ActionAid Bangladesh. It is a privilege for me to present the vote of thanks. But being an activist, I'm not going to be too structured. The whole reason for all of us coming together is the voices of the people and the oppression and the violation that we have seen and that is still continuing. The legal matters are very complex. I'm leaving this room with a lot of questions, and I'm not sure I've fully appreciated and understood how this process of ICC and all the geopolitics is going to resolve the Rohingya crisis in the near future. Because what I read from all that is being said, it's going to be a very long, dragged process. Because we are talking about vested interests, we're talking about politics, and so on. But we are talking about people. And we must at least put that at the center of whatever we are considering. Whether it is the ICC option, whether it is the government of Bangladesh taking this up, whether the international community is going to take this up, we are talking about women, men, children, and their future, their existence. Future is pretty, far away. It's about today. And I don't have a lot of hope, given that what's happening in Palestine, while the rest of the world is looking on, given what has happened in Syria, I'm not leaving with a lot of hope. My only hope is how resistant and resilient the people are. When I went to the camps in August and when I go back now, I see a difference. And the difference is coming from the resilience of the people in the camps, their desire to continue to live. I mean, you must be in a very dire condition, in the worst condition to flee to Bangladesh, which is not a poor, rich and developed country, to live in those camps. But they still think it's a better option because they received a certain amount of dignity and they felt secured. So what next? Because we have 100,000 children being born, all the crimes that have been committed. And from the conversations today, what I have concern is about impunity. The international community has provided impunity over and over and over again. So what's going to change? We're still talking about geopolitics and political economy. So what's going to change? So this is what I'm taking back from here. And I think as people, we want to keep the stories going. We want this to be on the agenda. And we urge the government of Bangladesh to make that submission by the deadline. That does, many speakers before me have said, it has no impact on the bilateralism. That should continue. And so should the international pressure. We all have to come together. There are technicalities about collecting evidence, testimonies, I understand. But nothing stops us from taking the stories and putting it on the global platform, on everybody's agenda, and reminding us that today, right now, it's still happening. There are lots of international, national stakeholders. We will all put our efforts together. Some of it will be within the structure and the framework, some of it may not be. But please remember that somehow a narrative was created which the Myanmar citizens bought and believe in, and that is why it could happen. And it has happened to us in Bangladesh. We know how the narrative was created and the West Pakistanis, how they committed the genocide. So we can't forget that. So the narrative needs to have a counter narrative, and that's why we are a part of this process. The three organizations held the conference in April. We had the Dhaka Declaration, and as a follow-up, we have organized this seminar. We hope that together we can create a certain amount of interest and pressure on the government to make the submission, and there's no stopping us from making a submission. Because, and as we have heard, even the victims can make a submission. So I will just end by saying, they are human beings we are working with. While all this legality and the I's and the T's get cut and put in place, so let's be with them and let's try and keep our advocacy going. There is an exhibition from a people's perspective, from the lens of a Bangladeshi photographer, Mahmood, out there. I would welcome you to see that. I'm sure Shahidul Alam has many such exhibitions going on. Let us see, and let us all work together to bring that change. We can't accept this in this day and age. Thank you.
Ladies and gentlemen, we are almost at the end of the international seminar. I would request Ms. Farah Kabir ma'am to present our distinguished guests with a small token of thanks on behalf of the organizers.
আমাদের মিডিয়ার ভাই বোনেরা, আপনারা যদি আমাদের সঙ্গে এরপরে কথা বলতে চান, আমরা এখানে আছি। আজকের আলোচনার মূল বক্তব্য ছিল যে আমরা আমাদের সরকারকে অনুরোধ করব তারা সময় মতো যেন এই সাবমিশনটা দেয় এবং আন্তর্জাতিক যেই চাপটা দরকার সেই জায়গা থেকে তারা যেন আইসিসির কাছে যায় এবং মিয়ানমারের সঙ্গে বসে যদি সমাধান করতে পারে তাতে তো কোনো অসুবিধা নাই, দুইটা প্রক্রিয়া একসঙ্গে চলতে পারে। কিন্তু বিশেষ যে জিনিসটা আমাদের সবার মনে রাখতে হবে, এতগুলো মানুষ ক্ষতিগ্রস্ত হয়েছে, অন্যায় হয়েছে, ধর্ষণ হয়েছে, খুন হয়েছে, এটা ভুলে যাওয়ার কোনো উপায় নাই। এবং যদি দ্বিপাক্ষিক বা বাইল্যাটারালি এটা সমাধান হয়েও যায়, ওই বিষয়গুলোকে আমরা কি করব? ওই বিষয়গুলোকে আমরা কোথায় নিয়ে যাব? আমরা কি ভুলে যাব যে মেয়েদের উপরে ধর্ষণ হয়েছে? আমরা কি ভুলে যাব যে আমাদের নারীদেরকে ধর্ষণ করার পরে তারা এখানে এসে সন্তান জন্ম দিচ্ছে? এটা তো আমরা ভুলে যেতে পারি না। যেই শিশুর প্রতি অত্যাচার করা হচ্ছে সেটা তো আমরা ভুলে যেতে পারি না। তাই যদি হয় দ্বিপাক্ষিক পদ্ধতি বা দ্বিপাক্ষিক যে ব্যবস্থা আছে সেটা চলবে, আন্তর্জাতিকভাবেও আমরা এই জায়গাতে আমরা আশা করি যে বাংলাদেশের সরকার 11ই জুনের আগেই তারা এই সাবমিশনটা দেবে এবং আইসিসির ক্ষমতা যতটুকু আছে সেই ক্ষমতা ব্যবহার করে জবাবদিহিতার জন্য কাজ করবে। কেন মিয়ানমার এবং তার রাষ্ট্রের মধ্যে যেই সব সংস্থা বা মানুষ এই অন্যায় করেছে তাকে কোথাও না কোথাও জবাবদিহিতা করতে হবে, এর বাইরে কিন্তু কথা বলার সুযোগ নেই। আর আজকে আমরা যদি নিজেদেরকে একটা সভ্য পৃথিবী হিসাবে মনে করি, আমরা কি করে এখানে চোখ বন্ধ করে বসে থাকব? আমরা কি করে না এগিয়ে আমরা এখানে বসে থাকতে পারবো? আমার মনে হয় জবাবদিহিতার কথাটা আপনারা সবাই জানেন, আপনারা সবাই বিশ্বাস করেন এবং মিডিয়ার যে ভূমিকা সেটা হলো মিয়ানমারের উপরে এখন দৃষ্টিটা দিতে হবে, মিয়ানমারের সরকারের জবাবদিহিতার জন্যে কাজ করতে হবে। আন্তর্জাতিক মিডিয়া যদি না করে আমার দেশের মিডিয়া তো করতে পারবে। আপনারা সোশ্যাল মিডিয়া ব্যবহার করেন, আপনারা চ্যানেল ব্যবহার করেন, পত্রপত্রিকা ব্যবহার করেন, যে মিয়ানমারের সরকারের জবাবদিহিতা কোথায়? আর কতদিন আমরা বলবো যে আজকে চায়নার সম্পর্ক, ইন্ডিয়ার সম্পর্ক, রাশিয়ার সম্পর্ক, মাঝখান দিয়ে মানুষ মরে যাচ্ছে, ধর্ষিত হচ্ছে, শেষ পর্যন্ত হারিয়ে যাচ্ছে।
I'll just take 2 minutes. কয়েকটা জিনিস যে তিন বিশিষ্ট আমাদের ব্যক্তিত্ব যারা এখানে আসলেন, মিস্টার ফিলিপ রাডক, দেন কেট ভেগনিশরণ এবং জাস্টিস রিফাত, তাদের মধ্যে একটা বড় কনসেনসাস আমরা দেখতে পাচ্ছি যে তারা বলছে যে মিয়ানমারকে তার যেই অত্যাচার রোহিঙ্গাদের উপর করেছে সেটার জবাবদিহিতা সামনে আনতে হবে। বিশেষ করে আইসিসির যেই সাবমিশন বাংলাদেশ সরকারকে রিকোয়েস্ট করেছে এবং একটা ডেডলাইনও আছে 11ই জুনের মধ্যে, এবং তারা মোটামুটি আমি মনে করি যে আলোচনার মধ্যে একটা স্পষ্ট জিনিস এসেছে যে সাবমিশনের ব্যাপারে বাংলাদেশ সরকার যেন পজিটিভ একটা রিপ্লাই দেয়। এখন অনেকেই বলছে যে যেহেতু বাংলাদেশ সরকার দ্বিপাক্ষীয় একটা সম্পর্ক তৈরি করছে সেটা বুঝি মানে সেটা হয়তো ব্যাহত হতে পারে, বা যেহেতু বাংলাদেশের সাথে এই অঞ্চলে একাধিক দেশের সাথে সম্পর্ক আছে, সেই দেশগুলো হয়তো মিয়ানমারের প্রতি তাদের এক ধরনের দুর্বলতা আছে, সেখানে হয়তো আমাদের একটা সমস্যা হতে পারে। তবে আমরা যা শুনলাম তাতে বোঝা গেল যে দ্বিপাক্ষীয় যেই সম্পর্ক সেটা যে আলোচনা হচ্ছে সেই আলোচনা বজায় থাকতে পারে। সেটার সাথে এই আইসিসির যে সাবমিশন যেটা বলা হচ্ছে যে তারা যে ক্রাইম এগেনস্ট হিউম্যানিটি করেছে কিনা বা কোনো জেনোসাইড হয়েছে কিনা সেটার সাথে এক করার কোনো প্রয়োজন নেই, দুটো আলাদাভাবেই যেতে পারে। এবং এখানে যারা ভিকটিম, যারা একেবারে ক্ষতিগ্রস্ত হয়েছে তারাও কিন্তু সাবমিশন করতে পারে, এবং এমনকি বাংলাদেশেরও একাধিক সংগঠন অলরেডি তারা কাজ করছে এই ব্যাপারে। তো আমরা এই আলোচনায় যেটা আমরা দেখলাম সারাদিন যে হ্যাঁ একটা আইনগত অনেকগুলো বিষয় আছে, জটিলতা আছে, কোনো সন্দেহ নেই, সেগুলো আমাদের বোঝার বিষয় আছে। তবে আইনের প্রক্রিয়া যেভাবে আমাদের চালিয়ে যেতে হবে ঠিক একইভাবে আমাদের রাজনৈতিক, অর্থনৈতিক এবং বিভিন্ন যেই ক্ষেত্রগুলো আছে মানবিক সবগুলোই আমাদের কাজ করতে হবে, যার জন্য কাজ বড় আকারে পড়ে আছে। মনে রাখতে হবে যে ছোটোখাটো একটা ভুটান তৈরি হয়েছে বাংলাদেশের মধ্যে 3 মাসের মধ্যে, এবং ভুটানের চেয়ে বড়। যদি আমি জনগণের সংখ্যা যদি দেখি, সংখ্যা দিয়ে ভুটানের চেয়ে বেশি সংখ্যা এই 3 মাসে বাংলাদেশের মধ্যে বসবাস করছে, যার জন্য কাজটা বড়। তবে যেহেতু আমাদের 71-এর একটা অভিজ্ঞতা আছে, সেই 71 আমাদের রাষ্ট্রের একটা একেবারে যাকে বলা হয় একটা অংশ, সেই হিসাবে আমি এবং আমার যারা সহকর্মী আছেন আমরা সবাই বিশ্বাস করছি যে এই রোহিঙ্গা সমস্যা আমরা যদি আন্তর্জাতিক প্রেশারটা যদি বাড়াতে পারি আরও বড় আকারে, আমাদের বিশ্বাস যে মিয়ানমারের জনগণও একসময় বুঝতে পারবে এবং তারাও তাদের জনগণের, তাদের সরকারের উপরেও একটা প্রেশার আনতে পারবে, এবং তখন হয়তো আমরা দেখব যে আজকের যেই ক্ষতিগ্রস্ত যে রোহিঙ্গারা আছেন তাদের শরণার্থী যে অবস্থা আছেন সেটা থেকে তারা মুক্তি পাবেন। মিস্টার ফিলিপ রাডক খুব স্পষ্টই বলেছেন যে আমাদের স্যাংশনে ফিরে যেতে হবে। মনে রাখতে হবে যে মিয়ানমার কিন্তু একসময় স্যাংশনের দ্বারা আবদ্ধ ছিল, কিন্তু গণতন্ত্রের একটা আভাস দিয়ে সেই স্যাংশনগুলো সরিয়ে ফেলতে পেরেছে। তবে আমরা দেখেছি যে মিয়ানমারের গণতন্ত্র আসলেই গণতন্ত্র যেইভাবে বলে সেটা না, সেখানে 1/3 সামরিক বাহিনীর উপস্থিতি আছে, এবং দেখা যাচ্ছে যে সামরিক বাহিনী পুরো রাষ্ট্রটাকে চালাচ্ছে। তো সেই জায়গায় মিস্টার ফিলিপ রাডক উনিও বলছেন, এবং একাধিক আমি মনে করি ব্যক্তি বলছেন, আমরাও বলছি যে স্যাংশনটা আবার চালু করা দরকার। এবং উদাহরণস্বরূপ উনি এটাও বলেছেন যে যেহেতু ইরান বা নর্থ কোরিয়া এইসব দেশেও আমরা দেখেছি যে এক ধরনের স্যাংশনের দ্বারা মাধ্যমে কতগুলো জিনিস সমাধান হয়েছে বা সমাধান হতে যাচ্ছে, মিয়ানমারের ব্যাপারেও ব্যতিক্রম কোনো ব্যাপার না, যার জন্য মিয়ানমারে কিছুই করা যাবে না। সেই জায়গা থেকে আমি মনে করছি যে এখন আন্তর্জাতিক মহলে এই স্যাংশনের দাবিটাও বড় আকার করে আসছে। হ্যাঁ,
এ বিষয়ে কিছু দূর আলোচনা হয়েছে, এখানে কিছুটা আলোচনা হয়েছে, তবে এই ডকুমেন্টেশন একটা প্রচেষ্টা বা প্রয়াস চলছে, এবং কিছু গাইডলাইন্স বা টার্মস অফ রেফারেন্স
তৈরির পথে রয়েছে এবং এটা একটা স্ট্রাকচার বা একটা ফ্রেমওয়ার্কের আওতায় আনার একটা প্রচেষ্টা চলছে। তবে এটার মধ্যে আমাদের সবারই সম্মতি রয়েছে যে এই এভিডেন্স এখন জোগাড় করা, রেকর্ড করার সময় এসে গেছে। অবশ্যই, অবশ্যই, যখন আইনি প্রক্রিয়ায় যাচ্ছি আমরা, তখন এই এভিডেন্সটা দরকার হবে। একটা মিনিট, হ্যাঁ। How will the collection of evidence help in the dispensation? Collection of reliable evidence.